Michael Kempa is a professor of criminology at the University of Ottawa. He joins us right now. Michael, good to see you again.
Thank you. Thank you.
Now, you have been very clear in the past, you believe, or believed at least, that the government was justified in using the Emergencies Act. Why is that?
Well, it's very regrettable that it was necessary to mobilize the Emergencies Act. It was simply the case, though, that the normal chain of civil institutions, from municipal policing up through municipal government, provincial government, the federal security agencies, had not managed to bring the crisis under control. There were really no options left other than to mobilize the Emergencies Act, even though it should probably have never have gotten to that had our agencies been prepared in advance.
Had they been prepared? Now, was it just a matter, though, of giving them more time to respond rather than invoking the Act?
It wasn't a question of time to respond. Peter Slowly, the former chief of the Ottawa Police Service, gave very clear evidence on this last week to the Special Joint Committee in Parliament and the Senate on this matter, where he said most of the structural issues in our police organizations, in our different levels of government, we're simply not prepared for this magnitude of protest or crisis, and most of these structural issues have still not been repaired to this day. So it wasn't a matter of time in that moment. It was more a matter of really making sure that our police organizations are organized for this type of protest, our security organizations are asking the right questions and gathering the right information, and that we are prepared moving forward, having had to invoke the Emergencies Act once.
Okay, well, let's go back then. If the structures were insufficient, if the right questions were not being asked, why those deficiencies? Why weren't they better prepared? Was this just something that Canada has never seen before?
Canada's not seen it before. Our security agencies have not been focused on domestic, ideological, violent extremist groups, both on the far left and the far right. We had been focused on terror issues external to Canada, most especially a preoccupation with what was known as Islamist terrorism, which is different from the Islamic faith, obviously. This type of grassroots violent political extremism, though, has been a problem in Canada for at least a decade, and a growing problem, and our agencies were simply not focused upon it. And when we saw it approaching last January and February and bedding down in Ottawa, at the borders across Canada, and especially in Coutts, Alberta, with the discovery of weapons, we were surprised by what we saw simply because we had not imagined that it was this degree of a problem in our own country.
Now, I think there's a disconnect, though, because, of course, people will see the coverage. They will hear security experts like yourself talk about the concerns around national security, the type of danger that was present. But for many protesters, those who came out to support protesters, they still will argue that they have a right to demonstrate, and for them it was a pushback on vaccine mandates because that's what they came out for. It wasn't for any other reason, political or otherwise. What would you say to that?
Well, people certainly do have a right to protest and freedom of expression in Canada. There were layers to this protest. There were very many thousands of people who came out to protest vaccine mandates. The problem that we have, though, is that protest and the freedom of movement of individuals does not extend to heavy machinery and trucks and blocking public roadways and preventing essentially cities from being able to do any of their business and citizens to go about their daily essentials. So we don't have an unlimited right to free movement. The police are allowed to control the flow of traffic in our society, to make sure that emergency vehicles are able to get through and that citizens can access essential services like pharmacies and doctors and so forth. One of the issues we have had, though, is we don't have clear legislation in Canada that draws the distinction between where protest is legal and where it breaks down. In other places, in the United Kingdom, they do have this legislation. It's very clear. And it does not set undue limits on people's ability to freely express their opinions or to move around in nonviolent protest.
Okay, so what are the limits? If you're pointing to the United Kingdom as an example, what limits does the UK have that Canada does not have on the freedom of assembly and to protest?
Well, the UK legislation is very clear on not using heavy machinery or other objects to block public thoroughfares, public roadways. They're very clear on not having weapons of convenience, so things like flagpoles and whatnot that can be quickly broken down to use as weapons in crowds. They're clearer on the limits of hate speech and speech which incites violence. We do have limits in Canada, but they are a little bit clearer in the United Kingdom. They are things that allow police to act with more confidence in breaking up protest when it does begin to cross the line into illegality, while not interfering with legal protest.
Okay, but when you look at the charges that have come out of this action, they actually have nothing to do with violations of security. Instead, what we're looking at are mischief charges, nuisance charges. How do those crimes meet, or rather merit, the invocation of an Emergencies Act if, again, none of the charges laid have anything to do with security?
This is an essential question for the inquiry, and the tricky business for the public watching is simply that when you invoke the Emergencies Act, it enables the government to go into the law books to select certain tools to ramp up for a period of time. So in our case, we said this time certain areas were no-go protest zones. If you were participating in those zones or donating money to what was going on in those zones, you could have your accounts frozen and so forth. These were extraordinary powers that were basically designed to break up the crowd. When we're talking about laying charges, very often, even in a situation of emergency, Crown prosecutors and police will simply pursue the simplest charges that can be laid and taken up in the courts. So things like mischief, obstructing police officers, or assaulting police officers, these are straightforward charges that are easily prosecuted through our courts that do not require very complicated trials with very difficult standards of evidence. So the idea would be the Emergencies Act was for breaking up the crowd, but then in a sense, there's no reason to crush a butterfly on the wheel. Once you have people dispersed and you've only charged a small number of people, it's very often not necessary to use the most draconian laws for criminal prosecution. You can proceed with very simple charges that do not have enormous jail times associated with them, partially for the reason that you don't want to come down too heavily on people that may have a significant amount of public sympathy if you were to unnecessarily use huge laws against them in the courts.
But does that not undermine the justification for using the Act in the first place?
In a sense, it does. If there had been sufficient police officers in Ottawa with an adequate plan and procedures and policies in place to deal with a major protest such as what we saw in Ottawa, the enforcement of all of these conventional minor criminal offenses, mischief, damage to property, any forms of violence, open liquor, violation of moving violations for traffic in the city, it could have been broken up. The key being that these things were not in place. We did not have sufficient officers. We all saw OPS seeming to be hanging back, the Auto Police seeming to be hanging back for the justification that they said they would have been swarmed had they enforced many of these things. It got to the point where ordinary laws could not be used to break down up the crowd, and that's where the invocation of the Emergencies Act came into play. If we're ready next time, it should never again get to the point that the Emergencies Act would need to be mobilized for dealing with a protest of Canadian citizens in domestic territory.
Now, dozens of witnesses will be heard from in the weeks ahead. Is there any one or any group of particular witnesses that you're looking forward to hearing from?
They're all essential who are on the list. There was a bit of a debate. Should the organizers of the Freedom Convoy be given the platform to present their views in the inquiry? Absolutely they should. Canadians need to hear what is their side of the argument, what evidence have they got to support their claims that they were only here for a peaceable protest to do with COVID-19. They must answer questions to do with which streams of organization were tied to events in Coutts, Alberta. Was there coordination between the protests in Ottawa and the blockades of the essential crossings into the United States? Canadians must see and hear the evidence that these groups have and judge it for themselves.
Michael, really appreciate your thoughts once again. Thank you for the time today.
Thank you kindly.
That's Michael Kempa.